I'm Quieting Title. Hi, I'm Darren Findling of QuietTitle.com and the Darren Findling Law Firm. We're going to go over quiet title information to give you a better understanding of what the term means and how the process works. Let's get right at it. Quieting title relates to deeds that have been recorded in the chain of title. A deed, in this case I'm showing you a sample quitclaim deed, is a conveyance from the grantor, the party giving or conveying, to the grantee, the party receiving. That deed is a contract, an agreement to convey from person A to person B. And of course, a person can be a business entity, an entity, an LLC, a trust, etc. But it's a conveyance from one to another. Well, when a quitclaim deed is done or a warranty deed is done, those documents get recorded in the chain of title at the Register of Deeds. So a Register of Deeds records all the deeds on a particular legal description. So for example, if there's a deed in proper order from person A to person B, B to C, D to E, and so on and so on and so forth, that is called a clean chain of title. So when a title examiner looks at the title history at the Register of Deeds, they want to make sure that the deeds are properly ordered, properly signed, and that there are no breaks in the chain of title. If there is a break, maybe a missing deed, we call that a defect in title. Or maybe there was a failure from one party to convey to another, or one name was missed on a deed, or the legal description is incorrect, or maybe there was a mortgage and there had been a failure to record the discharge of mortgage when the mortgage was paid off. These are all examples of circumstances where a quiet title action may be needed, because the quiet title action is a lawsuit that is going to repair that missing deed. In this case, I'm using a deed example, but it could be a mortgage discharge that's missing or other defects that have occurred within the recording of those documents in the chain of title at the Register of Deeds. We simply call that a break in the chain. And I'm using this illustration of a chain because it's a really nice way to explain to people that, think of it like a chain on a bicycle. If there's a missing link on that bicycle chain, the bicycle doesn't work. And so too with the chain of title. If there's a missing deed, a defect in the deed, or many missing deeds or interests in the chain of title, the necessity to correct is to either get those documents from the required people or to file a lawsuit. And that lawsuit is called a quiet title lawsuit. It is a lawsuit that is typically filed in the county court in which the property sits. Typically, the plaintiff is the party trying to fix or correct the chain of title, and the defendant or defendants, if there are more than one interest, are the parties upon which the plaintiff is seeking to terminate their interest or have the court identify their respective interests relative to the parcel. So this lawsuit gets filed, it then gets served, and it goes through this judicial process, ultimately to resolve itself with a court order or judgment that gets recorded in that same chain of title that we just referred to where the deeds are recorded. So if a quiet title action is done and done correctly, and the court enters an order, it will clean all the historical interests that are identified in that lawsuit. It's a way of resolving, cleaning, or quieting the chain of title. At QuietTitle.com and the Darren Findling Law Firm, we are passionate about helping people with title-related issues. If you have questions and want to discuss your matter, call us 877-YOUR-FIRM, 877-YOURFIRM, or visit us at QuietTitle.com.